Evening. License and registration, please.
Sure, they're right here.
The blue lights hit the rearview mirror at 11:47 p.m. License and registration already in hand. Engine off, dome light on. Hands visible on the wheel. Everything by the book. Do you know why I pulled you over? One question, 8 words, and how you answer it in the next 5 seconds determines whether you drive away with a warning or whether you just handed the officer everything he needs to write that ticket. In your own words, I'm a criminal defense attorney with over 2 decades in courtrooms, and I've watched that exact question turn what should have been warnings into citations into arrests, and simple traffic stops into full-blown searches. By the end of this video, you are going to know exactly why that question is a trap, what the law actually requires you to say, and the one short phrase that flips the entire dynamic back in your favor. Now, let me be clear up front. This scenario I am walking you through is one I have built from patterns I see repeatedly across real cases, not one specific incident, but the legal principles, the case law, and the exact words you need. Those are all real, all tested, and all yours to use. So let's go back to that traffic stop. The dashcam timestamp reads 11:47 p.m. The driver, we will call him Marcus, was doing 73 in a 65. The officer knows it. Marcus probably knows it. The radar gun logged it. But here's what most people miss. The officer asking, "Do you know why I pulled you over?" isn't looking for information. He already has the violation. He is looking for corroboration, your own admission on video that makes his case airtight. Marcus does what most people do. He tries to be cooperative, maybe a little apologetic. Was I speeding? I'm sorry, officer. I didn't realize. I thought I was going the limit. Stop. Right there. He just did 3 things that made the ticket inevitable. First, he guessed. The moment you start speculating about what you might have done wrong, you are handing the officer a menu of possible violations. Maybe he pulled you over for a license plate light. Maybe it was a lane violation. Maybe he is fishing and doesn't have a solid reason yet. But now, you have just given him one by mentioning speed. Second, he admitted knowledge. I thought I was going the limit means you were actively monitoring your speed. You were aware of the limit and you made a conscious decision about how fast to drive. That destroys any argument later that it was inadvertent, that your speedometer was broken, or that you had no awareness of the violation. Third, he apologized. And I know that sounds minor, but in court, an apology on body cam is treated as consciousness of guilt. It's not legally dispositive on its own, but it's corroboration. It makes everything else stickier. Here's what the law actually requires in that moment. Nothing. You are not legally obligated to answer investigative questions during a traffic stop. The Supreme Court has been crystal clear on this since Berkemer v. McCarty in 1984. A traffic stop is a seizure under the 4th Amendment. And while you are required to provide license registration and proof of insurance in every state, you are not required to answer questions designed to build a case against you. And that question, "Do you know why I pulled you over?" is exactly that. It is investigative. It is designed to elicit incriminating statements, and you have every legal right to decline to answer it. So, what should Marcus have said instead? Here's the exact phrase, and I want you to memorize it because it works in every traffic stop, in every state, every time. I prefer not to answer questions. Here's my license and registration. That's it, 11 words. Polite, calm, legally bulletproof. You're not being rude. You're not refusing to comply. You're drawing a bright line between what the law requires you to do, provide your documents, and what the officer is hoping you'll do, which is talk yourself into a ticket. Now let's keep going with what happened in this scenario, because the stop didn't end there. The officer took the documents, walked back to his car, and ran the license. Clean record, current insurance, no warrants. He comes back, And here's where it gets interesting. I clocked you at 73 in a 65. That's 8 over. I'm gonna write you a warning this time, but I need you to sign here, acknowledging you were speeding. And Marcus, wanting to cooperate, wanting this to be over, signs it. Wrong move. Here's why. In many states, signing a warning that includes an admission of the violation can be used against you if the officer changes his mind and upgrades it to a citation, or if there's a subsequent stop later and the prosecutor pulls your history. You've now created a documented, signed admission of a speed violation. Some states even allow warnings to be introduced as prior conduct evidence if you fight a later ticket. What should he have done? Simple. I'm not comfortable signing a statement that includes an admission. If this is just a warning and you're letting me go, I'll accept that, but I'm not signing an acknowledgement of a violation I haven't been cited for. Is the officer gonna like that? Probably not. But here's the thing. His feelings are not your legal responsibility. Your job in that moment is not to make the officer happy. It's to protect your rights and avoid creating evidence that can be used against you later. Let's talk about what happens if the officer pushes back. If you don't sign, I'm just gonna write you the ticket instead. That's coercion. And it's not uncommon, but it's also legally shaky ground. For the officer, a signature on a warning is supposed to be an acknowledgement that you received it, not a confession. If it's truly voluntary, then refusing it shouldn't change the outcome. If refusing it does change the outcome, that tells you it wasn't about documentation. It was about getting you on record. At that point, your best move is still calm and clear. I understand. If you feel you need to write a citation, that's your decision. But I'm not going to sign a statement that admits fault. Now, in the scenario I'm walking you through, he let Marcus go with a verbal warning, no signature, no ticket. But here's the kicker. Lucas's case only stayed clean because he stopped talking after that first mistake. If he'd kept going, kept apologizing, kept explaining, there's a very good chance that warning would have turned into a citation. Anyway, I've seen it happen 100 times. The officer's walking back to his car. The driver rolls down the window and calls out, "Hey, I'm really sorry. I'm late for work. I've been stressed. I wasn't paying attention." How thing a trest and can extract Drockfinson. And now you've just added distracted driving to the mix. You've handed him a second violation on a silver platter. The legal principle here is simple, and it comes straight out of the Fifth Amendment and 50 years of Supreme Court precedent. You have the right to remain silent, and that right applies the moment a government agent starts asking you questions. As part of an investigation, traffic stops are investigative seizures. The questions are part of that investigation. You are not legally required to help the government build a case against you. And yes, I know it feels rude. It feels like you're being uncooperative, and we're socially conditioned to answer when someone in authority asks us a question. But that conditioning is exactly what that question is designed to exploit. There's a reason the first thing out of the officer's mouth isn't, "I pulled you over for going 73 in a 65. That would be clear, honest, and wouldn't give you a chance to incriminate yourself further. Instead, it's phrased as a question because questions feel like conversations, and conversations feel voluntary, and voluntary statements are admissible. But you're not having a conversation. You're being investigated, and the law gives you every right to recognize that and respond accordingly. One more thing, and this is important: declining to answer questions does not give the officer legal grounds to extend the stop to search your car or to escalate the situation. The Supreme Court made that clear in Rodriguez v. United States in 2015. A traffic stop can only last as long as necessary to resolve the reason for the stop. If the officer has already identified the violation and written the ticket or decided not to, he can't hold you there to fish for more just because you didn't chat with him. If he tries, you ask one simple question: am I free to go, or am I being detained? If he says you're being detained, you follow up. What is the legal basis for detaining me beyond the original reason for the stop? You're not arguing, you're not debating, you're creating a record on his body cam that he extended the stop without legal justification. And if it ever goes to court, that record is gold. So let's bring this full circle. That one question. Do you know why I pulled you over? Feels harmless. It feels like the start of a normal interaction. But it's not. It's the officer's first move in building a case. And how you respond determines whether you're helping him or protecting yourself. You don't guess. You don't apologize. You don't explain. You hand over your documents and you stay calm and polite. And you say, I prefer not to answer questions. And then this is key. You stop talking because every word after that is a gift to the prosecution. Now, traffic stops are just one scenario where knowing your rights and knowing exactly what to say can change the outcome completely. But what happens? When it's not a traffic stop? What happens when officers show up at your door? No warrant, just questions, and you make the mistake of opening it? That's next.